Seat, sir.
Y'all remember from the transcripts, he said, nah, I want to go in there just like this. I want them to see what y'all did to me.
Good morning again, sir.
Good morning.
Okay. Sir, it is your intent to testify today. Is that correct?
Yes.
Okay.
There is a lot of information in this motion. We're going to go through some of it, not all of it. There are over 233 pages in this motion, and y'all are going to be very interested to hear some of the things that he's talking about in the motion. So let's go ahead and get right into it, giving you guys a little bit of background. What happened was on Monday, the court was supposed to respond to the 3 recusals that were filed by several of the lawyers and defendants involved in this case. They decided yesterday that they needed a little bit more time and asked Judge Rachel if they could give them a little bit more time to respond. So she said, okay, I'll give you 48 hours. So you have until Wednesday at the end of the day to respond, right? That was Judge Krause. So now that they had this time, Brian Steele took advantage of that. And he said, hey, we're going to drop this supplemental motion to recuse Judge Glanville on your head. So now you have even more that you have to respond to. So I don't know what they're going to do in this case as far as how soon Judge Krause is going to make a ruling on this, but we're going to go through it and see what Brian Steele is talking about and what he's saying. All right. So y'all get ready, because there's a lot of interesting facts in this. Some of the things that we didn't even know were going on, or that some of the prosecutors involved in this case are going through. All right. So in the Superior Court of Fulton County, State of Georgia versus Jeffrey Williams is the defendant. And this is an indictment number here. Judge Glanville, supplement to motion to recuse Judge Glanville. All right. And we've got a bunch of notes in here we're going to go through as well. Comes now, Young Thug and through undersigned counsel, and hereby timely files this supplement to motion to recuse Judge Glanville in the above referenced case. In support of this motion, Young Thug shows as follows. 1. This supplement motion to recuse Judge Glanville, as well as the attached joint affidavit, and there's a lot in this affidavit too, is timely filed as Uniform Superior Court Rule 25.1 mandates that the time for filing a motion to recuse shall be not later than 5 days after the affidavit first learned of the grounds. Okay. And then they've got a couple of notes here. The first note is who this supplement to motion to recuse is about. Number 1, this motion applies to lawyers Love and Hilton. In addition to Judge Glanville, as all 3 are material witnesses in the case at bar, and all will be called by Mr. Williams during trial to show judicial and prosecutorial, hopefully I said that right, misconduct. All right. And then you can see the case stated there. This motion also timely moves to recuse the Honorable Judge Krause based upon the fact that she sits on the Fulton County Superior Court bench with Judge Glanville, and that in April 2024, Judge Glanville contributed $2,000 to the Honorable Judge Krause's re-election campaign. I told y'all, man. I know I wasn't the only one. I wasn't the first one to see this, but this is some of the concerns that we had when it came to this whole entire case being seen by another judge in Fulton County. They are all connected. And I know Judge Glanville isn't technically their boss, but there is a hierarchy within the system. Judge Glanville knows and is connected to them. We talked about Judge Belinda. He's known and worked with her for 7 years. There's been cases that they've worked on together. And now you have Brian Steele calling out Judge Krause, the Honorable Judge Krause, so still showing some respect there, and saying that, hey, Judge Glanville is already biased. Judge Krause is biased because he contributed to her re-election campaign, which is absolutely insane. Also in April 2024, the Honorable Judge Krause donated $500 to Judge Glanville's re-election campaign. Oh my gosh. Young Thug's trial has been ongoing since January 4th, 2023, and therefore includes April 2024. So while this case was ongoing, he I guess he didn't foresee himself having an ex parte meeting that would essentially ruin this entire case. But hey, what are you going to do? See, and then they cite this case as well. And then the third note, undersigned counsel derives no happiness when filing this supplemental motion. However, let justice be done though the heavens fall. Actually, the heavens will not fall by unmasking unbiased and unethical members of the bar. Oh my gosh. Oh man, they are putting all types of icing on this. Brian said, hey, you know, whatever case may be, we just have to do what's right. And actually, it's not that big of a deal because we need to get them off of this case as soon as possible. All right, so let's go back a little bit. Let's see. So the timely filing mandates the time for filing a motion to recuse shall be no later than 5 days after the affidavit first learned of the grounds for disqualification. See Exhibit A. That is the affidavit. All right. The Honorable Supreme Court of Georgia has taught that a motion to recuse is timely filed under this section if it is filed within 5 days after the affidavit first learned of the alleged grounds for disqualification, excluding Saturdays and Sundays. See, and then they cite some more. All right. Thus, the supplement to motion to recuse is timely and has the additional reasons for the recusal were first learned on Monday, July 1st. OK, definitely within 5 days when Judge Glanville permitted the court reporter to release to undersigned counsel the transcript of the Monday, June 10th, 2024 ex parte meeting between Judge Glanville, lawyers Hilton and Love, the Honorable. I love how he doesn't say honorable in front of Judge Glanville. He's not feeling them. And he doesn't say it in front of lawyers Hilton and Love. He doesn't even use their whole name. Dang, that's crazy. The ex parte meeting between Judge Glanville, lawyers Hilton and Love, the Honorable Attorney Bumpus, and her client, sworn witness Lil Woody, and others. Right. And they talk about that in the affidavit as well. This timely filed supplement to motion to recuse has also been timely presented to the Honorable Judge Krause and Judge Glanville. They left out honorable again. Sheesh. On Monday, July 8th, 2024. In the case at bar, Judge Glanville's ex parte communications with a sworn witness, his counsel, lawyers Love and Hilton. Ooh. Oh my gosh. Oh my gosh. Yeah, did I say Judge Honorable Attorney Bumpus? Excuse me. So he's calling Miss Love and Miss Hilton his counsel. That's tough, man. In the case at bar, Judge Glanville's ex parte communications with a sworn witness, his counsel, lawyers Love and Hilton, and other representatives with the Fulton County District Attorney's Office are seemingly only partially captured by the court reporter. They're basically saying what we said when we reviewed this transcript. It looks like they didn't release the unredacted transcript. Either that or there was a fly in the room and the court reporter the whole time was just waving the fly and couldn't keep track of everything because there was a lot missing from those transcripts. All right. Judge Glanville, lawyer Love, and lawyer Hilton have prejudiced and tainted Young Thug's trial so deeply as Judge Glanville has not acted as a judge, but morphed into an essential part of the prosecution team. God. And we saw this before in what Mr. Weinstein sent to the Superior Court of Georgia before, which was crazy. It's crazy that Brian is going at them. Judge Glanville has not acted as a judge, but morphed into an essential part of the prosecution team. For instance, see Johnson v. State, and then they cite that's case there. The judge's conduct, including ex parte communication with the prosecutor during trial, resulted in an appearance of bias, requiring reversal of the convictions and sentences. USCR 4.1 mandates that judges shall neither initiate nor consider ex parte communications by interested parties or their attorneys concerning a pending or impeding proceeding. And we talked about this. Not only did Judge Glanville and Miss Love talk about having a meeting on Monday in open court. But they also, in the transcripts, as we see, Judge Glanville was the one who said, hey, can y'all bring little Woody in here? We're going to have a meeting. We need little Woody in this meeting. So he was the one that set this whole thing up, which is not a great look at all. Yet Judge Glanville participated in these ex parte communications and then somehow attempted to keep the secret by referring to the meeting as privileged. Okay, we didn't see that in the transcript, so I'll be interested to see if more information comes out of where he called it privileged, because Kayla mentioned as well that he never said the meeting was privileged or that people weren't supposed to know about it, and describing the improper secrecy as sacrosanct. All right, and then they give another exhibit C. Judge Glanville has totally abandoned his role as a judge and has become a prosecutor against Young Thug. It's looking that way, man. It's definitely looking that way. Ex parte communications are presumed to be harmful error, and any conviction and sentence will be reversed unless the state proves that the error was harmless, which they're going to have a really hard time doing. Mr. Williams, or aka Young Thug's timely raised his objections to these ex parte communications and recusal of Judge Glanville, to wit, when he first learned of the same. All right. And then they're saying sacrosanct means most sacred or holy, inviolable, immune to criticism. Okay. And then they give the definition there. As shown herein, the ex parte communications were illegal, immoral, and unethical, diametrically opposed to sacrosanct. We would have to agree. This should have never happened. Canon 2 rule. Okay. We got the Georgia Judicial Code of Conduct forbids a judge from considering ex parte communications as judges shall accord to every person who has a legal interest in the proceeding or that person's lawyer the right to be heard according to the law. Judge Glanville embraced his view that the communications at the ex parte hearing were privileged, which still doesn't make sense that it would be necessary. They can still be harmful. Judges, okay, so they cite the exhibit here, and it says that judges shall not initiate, permit, or consider ex parte communications or consider other communications made to them outside of the presence of the parties or their lawyers concerning a pending or impeding proceeding, except communications for administrative purposes, emergencies, consultations with experts, or court personnel and settlement conferences. Okay, Judicial Code Rule 2.9. It is also clear that ex parte communications are presumed to have been in error, and once a party has shown that a judge has received an ex parte communication, there is a presumption to harm that can be overcome only by affirmative showing that the judge did not consider this communication, which that's impossible because he's the one that made the entire meeting happen. In the case at bar, there is not a, I don't even know how to say this. There is not a, what is it? Scintilla? What is that word, man? I'm gonna have to look that one up. Of evidence, but there's basically no evidence to overcome the presumption that these impermissible, illegal, and unethical ex parte communications as captured in attached Exhibit B result in harm. Thus, Young Thug's case should be reversed on direct appeal if there is any conviction and sentence. Okay. And then they cite this line here, or there's a note here. It says Georgia's current code of judicial conduct went into effect January 1st of 2016. Okay, good to know. And then they say compare this situation. He said ex parte letters sent to the judge by witness was not harmful error, where the party asserting the error did not argue that the judge responded in any manner or gave the letter any consideration. Okay, so this is a case where the judge did the right thing. As shown in the joint affidavit attached here too as Exhibit A, Judge Glanville not only conducted this improper and unethical ex parte meeting, Judge Glanville therein acted as an advocate for the Fulton County District Attorney's Office as he dispensed legal advice and supported lawyers Hilton and Love's goal to have Lil Woody testify against Young Thug and the other co-indictees. I mean, he was a part of the prosecution, because with the absence of the defense being there, there is no back and forth at all. You can't hear both sides. You can't be unbiased or impartial if you're only there hearing and helping one side. Man, and Brian's putting this a different way that we've heard before, and this just makes it sound even worse. And then we looked throughout the transcript from the secret meeting, and we saw Judge Glanville is even in there coaching and echoing some of the things that ADA Hilton was saying, which is just, it's sad to see that this is how the justice system's being run here. In light of this ex parte proceedings, it is impossible to conclude that Judge Glanville is impartial and not a member of the prosecution team. God dang. Judges shall disqualify themselves in any proceeding in which their impartiality might reasonably be questioned, including cases in which the judge has a potential bias or prejudice concerning a party or a party's lawyer, or personal knowledge of disputed evidentiary facts concerning the Proceedings Code Judicial Conduct Rule 2.11. Judge Glanville has been derelict in his judicial duties and must be recused. Once evidence of this illegal ex parte Star Chamber meeting was revealed by undersigned counsel in the afternoon of June 10th, 2024, in open court, lawyers Hilton and Love sat mute while Judge Glanville found undersigned counsel in contempt of court. He's talking about himself, and sentenced undersigned counsel to the longest possible time in jail for unmasking Judge Glanville's, lawyer Love's, and lawyer Hilton's improper, illegal, and unethical conduct. All right. And he's going to go into a little bit more of what some of the consequences should be for what they did. Check this out. Brian says, in addition to violations of Georgia rules of professional responsibility, which could carry penalties up to disbarment, felony crimes such as a violation of oath of office as codified here. Wow. Brian is, this dude is not letting up. He said, hey, we got to get him up out of here. Not only that, but they could be charged with felonies. They could get disbarred. And their livelihood is at stake here. Whew. Judge Glanville must be recused from any further action on Young Thug's case. The reference sections of the Georgia Code of Judicial Conduct are meant to be self-enforcing, and it is the judge's duty to disqualify himself as soon as he is aware that the grounds exist. All right, so how is Judge Glanville going to respond to this and defend himself? No wonder they needed some extra time, because he has this to respond to, along with 3 other motions to recuse. I don't know, and I cannot see a way that he's going to be able to say, oh, this meeting was okay, I should have had this meeting without the defense there, other than him saying it was privileged, which, looking at some of these cases that they're citing, he still wasn't allowed to do that. All right, so they said see Pope versus State. All right, which provides that no justice, judge, or magistrate shall accept from the parties to the proceedings a waiver of any grounds for disqualification, including cases in which judge has personal knowledge of disputed evidentiary facts concerning the proceedings. Okay. And then they cite some more cases there. In the case at hand, the state cannot show that Judge Glanville's, lawyer Love's, or lawyer Hilton's intentional and willful complicity in these ex parte communications was harmless error. And I agree with Brian on that. I mean, any reasonable person would look at this and just say, this is wrong. There's no way they should have been able to hold this meeting and thought it would be okay without the defense being there. As shown in Exhibit B, the improper influence and interjections by Judge Glanville. I'm guessing Exhibit B is probably the transcript, if I had to guess, but we'll see later on. As shown in Exhibit B, the improper influence and interjections by Judge Glanville and his 2 cohorts from the Fulton County District Attorney's Office on Lil Woody's changed Lil Woody's stance not to testify against Young Thug. If Lil Woody refused to testify, all of his prior false inculpatory statements as to Young Thug would not come into evidence based on Young Thug's constitutional right to confrontation. Intimidation tactics thrust upon Lil Woody by the combined work of Judge Glanville, Lawyer Love, and Lawyer Hilton resulted in Lil Woody's decision to testify, and thus Lil Woody has another witness to challenge at trial. That's true. Moreover, ex parte communications are so disfavored and repugnant jeez, that even if the ex parte communications would be cumulative of other evidence introduced at trial, same would not be harmless error because the ex parte communications are presumed to be reversible error. So no matter what the ruling is in this case, Brian's saying, hey, even if we make a ruling, we make it all the way to the end of this case, you would have wasted everyone's time because we're going to appeal to get this reversed, and it would have to be reversed because this meeting even took place in the first place. Oh man, Young Thug's fundamental constitutional rights were trampled, ignored, and violated as a result of Judge Glanville, Lawyer Love's, and Lawyer Hilton's improper, unethical ex parte meeting with witness Lil Woody. And Lil Woody's rights were trampled as well because he had forced immunity. So they forced immunity on him, made it so that he had to testify. That wasn't in this ex parte meeting, but still, I mean, Lil Woody didn't have a choice either, it seems like. Moreover, the cover up, secrecy, and silence of all three team members, he calls them team members, is unforgivable. To wit, after the Star Chamber meeting, the three public officials simply strolled into the courtroom, faced the cameras, called for the jury, and asked to continue the trial as if nothing out of the ordinary occurred just hours/minutes before. All right, and then they actually show a YouTube video where this happened. It's about 7 minutes where they come in. We haven't seen this yet, so I think we might go into it and look at this. Shout out to Law and Crime. Let's go to the 2:28 mark. So they put this timestamp in here because this is right when they come out of the secret meeting with Kayla and Lil Woody. So let's see what they look like in here. Hold on. Let me skip forward a little bit. It says 2:28:40.
Now come to order.
There you go.
Good morning, y'all.
Look at him, guilty. Disgusting.
All right, ladies and gentlemen, we are back on the record in the matter of the state of Georgia versus Khalif Adams et al. In 22 SC 183-572. All right, let me go ahead and take roll for today. Let's see, Mr. Stillwell, Mr. Boston, Mr. Shar. Good morning, gentlemen.
This is when it all went
Mr.
down.
Williams, Mr. Steele, Mr. Adams. Good morning. All right, Mr. Kenrick and Mr. Weinstein. Good morning. All right, Mr. Huey and Mr. Matthews Jr. and Sr. Good morning. All right, Mr. Nichols and Mr. Garner. Good morning.
Wow.
Mr. Ryan and Misty Williams. Good morning. All right, Mr. Brown, Mr. Uhelski, Mr. Atkins.
Trying to see if Kayla's in here yet.
Miss Love.
Miss Love.
You see here? No.
There's our guy,
Right.
Young Thug.
Good morning.
The GOAT, Brian Steele.
All right. Are all the jurors present, sir?
Yes, sir.
Okay. All right. Anything I need to take up before we
And there they
before we
are.
call for Mr. Copeland? All right. Mr. Steele, you don't have to if you don't want to. I mean, it's okay.
I want to.
All right, go ahead.
I'm just, I don't know what is going on. Last we know, you said
Uh-oh.
you have a hearing with his lawyer.
I'm sorry. I didn't quite hear you talking a little low.
Said, I don't know what's going on. Last I learned, you said that there'll be a hearing this morning with his lawyer. And been dark since.
He's had, okay. Mr. Copeland's had the opportunity to speak with his lawyer, Miss Bumpus, and it is my understanding he's going to testify. That's the latest I can give you, okay? So we're going to bring Mr. Copeland out, and we'll see what happens, okay?
Did the court send the immunity order?
It should be filed. It should be part of Odyssey.
Brian is heated right now. He knew what happened.
Because it would have been filed, I think, on Friday. So,
I don't believe anyone.
Miss Love, did you file that already?
We left the yellow envelope with the court for a signature. We were going to file it under seal.
You mean the motion? Okay.
We can give them. We can send them.
Yeah, if you could
Look
send
at him.
them a
He's
copy,
still
that'd be
coaching
fine.
him up.
Okay. Send them a copy.
Crazy thing is, at this point, they had no idea that Brian Steele knew about the ex parte meeting, which is hilarious. But fast forward a little bit more.
Good morning.
Okay.
There's our guy. There's
Mr.
little
Copeland,
Woody.
have a seat, sir.
Y'all remember from the
All right, go-
transcripts, he said, nah, I want to go in there just like this. I want them to see what y'all did to me.
Good morning again, sir.
Good morning.
Okay. Sir, it is your intent to testify today. Is that correct?
Yes.
Okay. All right. Some of our jurors, please, Sergeant Ingram.
And he said, good morning again. Where's Kayla at? I'm trying to see where Kayla is. And the jury comes in, and then they said we're gonna go till 3:35:42.
Ladies and gentlemen of the jury, good morning. All right.
All right, and all they wanted to show here is that Judge Glanville, ADA Hilton, and ADA Love didn't care. They just didn't care. They had this secret ex parte meeting. They knew what they had done, and they called everybody in there. They told Lil Woody, all right, man, come on. We talked about this. Go ahead and testify. All right, so going back to this motion. It says Young Thug needs to examine Judge Glanville, Lawyer Hilton, and Lawyer Love, and all other members of the prosecution team to reveal the date and time of every ex parte communication that occurred concerning Young Thug's case since its inception. The subject of same, and order the court reporter to produce any transcript of same and or unseal all documents from the potential improper ex parte meeting. Brian Steele is saying this isn't the first time they've done this. And he's not even saying, the wording here is saying that he believes or he knows somehow that there were other ex parte meetings as well. Listen to this. He said, basically everyone on the prosecution team needs to reveal the date and time of every ex parte communication that occurred concerning Young Thug's case. He's not even questioning that it happened. What does he say here? Undersigned counsel needs to cross-examine all of these parties to ensure that the sworn testimony is spread in open court on the record. Let's see if we can find note 7. It says, undersigned counsel objects to any proffer by Judge Glanville, lawyers Hilton and Love. Other objections to proffers will be made at the time of the attempted proffer. Okay, proffer, excuse me. Yeah, so basically they can't argue against this and they've just got to get it done, which is wild. So what information are we missing here? When have these other meetings taken place? Because Brian seems to be pretty sure that other ex parte meetings have taken place. And I don't know if he heard this from, it wouldn't have been Kayla because she was only there from one day. If he heard it from somebody else, so maybe there's another mole. This is wild, man. Somebody said she was sitting with Young Thug's family. Oh, okay. She said she was sitting in the back in another interview too. Yeah, we probably can't see her. Can't see her for some reason. Anyway, Mr. Young Thug's trial is constitutionally broken based upon the unconscionable misconduct of Judge Glanville, Lawyer Love, and Lawyer Hilton, all working together in an effort to convict Young Thug. The criminal justice system in Fulton County, in the state of Georgia, and in America has been attacked by the conduct of these three actors. Sheesh. The injustice must end immediately, beginning with Judge Glanville removed and disqualified from Young Thug's case. Thereafter, this motion is also timely made for Lawyer Love and Lawyer Hilton to be removed and disqualified from Mr. Williams' trial. And the Fulton County District Attorney's Office must be investigated for their improper conduct, if any, outside of the actions of Lawyer Love and Lawyer Hilton. Okay, so they're insinuating more may have happened there as well. Judges must scrupulously avoid improper ex parte communications, whether or not they consider them. All right, a judge has the ethical duty to recuse himself anytime the judge is aware of grounds to do so. Judge Glanville did the opposite of recusing himself, even it's sua sponte, even though he is keenly aware that helping Lawyer Love and Lawyer Hilton to influence Lil Woody to change his mind and testify against Young Thug is not permitted by any judge in any court. Instead, Judge Glanville, the chief judge in the Superior Court of Fulton County, Georgia, has taken upon himself, at the behest and encouragement of Lawyers Love and Hilton, to ally himself with the prosecutors in this case. Judge Glanville's misconduct shall not stand. All right. The law must be followed. Judge Glanville must be recused and disqualified from Young Thug's case instanter. I don't know what that means either. I've never heard it used that way. No hearing is actually needed to reach the finding that the recusal of Judge Glanville is mandated. So how would they go about this then? I guess we'll have to keep reading. Judge Glanville has automatically caused his recusal and disqualification from Young Thug's case by unlawfully becoming actively involved when he presented argument refuting affidavits alleging of judicial bias. Okay. And then they have a timestamp here. We're not going to watch the whole thing because it's 12 minutes, but we might clip that and put it in the video at some point. If the honorable court disagrees, Young Thug respectfully requests a hearing, as he will call Judge Glanville, Lawyer Love, and Lawyer Hilton as witnesses to fully unmask this above discussed misconduct, as well as further misconduct that may have occurred. And Kayla even said if she is subpoenaed and if she has to come testify at this hearing, she said, I would be more than happy to. Which is crazy. And we know Lil Woody, he'll be more than happy to say what happened too, because we already saw him on a YouTube video saying that the transcripts weren't true. So I don't know why Judge Glanville needs more time. He needs to go ahead and recuse himself, get off of this case. It's already such a mess. And then you have on his side somebody who he contributed and who contributed to his reelection that's ruling on these recusals. I mean, it doesn't make any sense at all. But his pride's in the way. He doesn't want to recuse himself. And I think this would be another big stain on this already huge mark against the Fulton County court system. I mean, you look at everything that happened with Fonnie Willis, just to start. The judicial and prosecutorial misconduct denotes a disgraceful episode in the Fulton County courts. I agree. Fulton County District Attorney's Office and stains courts throughout the state of Georgia and our country. Sheesh. What occurred in this star chamber outside of the view of the cameras, in the shadows, and hidden from Young Thug and his counsel and the public is unpardonable, and all in violation of Young Thug's constitutional rights stated herein, as well as in Exhibit A. Judge Glanville's Lawyer Love and Lawyer Hilton have created secret star chambers proceedings with the state of Georgia has promised its citizens, which the state of Georgia has promised its citizens it would never engage in. Okay. And then they cite the case there. As the Honorable Supreme Court of Georgia has taught, justice faces its greatest threat when the courts dispense it secretly. Our system abhors Star Chamber proceedings with good reason. Oh, wait. Judge Glanville, Lawyer Love, and Lawyer Hilton have teamed up to conduct their illegal and unethical conduct outside of the view of Young Thug and his counsel, the public, and outside of the lens of the cameras. I mean, if Brian keeps harping on this point, there's no way that Judge Glanville can argue this. There's no way he can say that this isn't what took place. We've got the transcripts. He never denied that this happened, and he encouraged it. He thought it was okay. Why? We'll never know. We probably will know if there's a hearing, because I have a feeling even if they respond by tomorrow when they're supposed to, there's still going to be a hearing, and it's not just going to, Judge Glanville's not just going to recuse himself and say, all right, I'm off the case. No, this is going to be a long fought fight, and this case is going to be paused for who knows how long. The public officials shall never be trusted by Young Thug or undersigned counsel. These are serious consequences for the intentional and unjustified misdeeds that have not yet been dispensed. The clear evidence is that Judge Glanville is not impartial, and or there is at least the appearance that Judge Glanville is not impartial. Judge Glanville must be removed / disqualified from Young Thug's case. As sworn to in Exhibit A, Judge Glanville, Lawyer Love, and Lawyer Hilton conspired to conceal and suppress evidence. This Star Chamber cannot prohibit Brady evidence from coming forward. We haven't talked about the Brady evidence so much, but we might get to that in another video. This is exactly what Judge Glanville, Lawyer Love, and Lawyer Hilton plan to do with Young Thug's constitutional right to due process, a fair tribunal, a fair trial, effective assistance of counsel, right to cross-examine, right to see, hear, and be present for statements of a sworn witness have been obliterated by Judge Glanville and his cohorts. Judge Glanville must be removed as he has forfeited his position as judge. God. Woo.